All right, we are live.
All right, everyone, welcome back. It's shortly after 2:30 on Wednesday, April 22nd. We are picking up continued work on S-298, an act relating to creating the Vermont Voting Rights Act. We are going to start things off with Legislative Council and then get into a slug of witness testimony.
Company committee members, for the record, my name is Tim Devlin, Legislative Counsel. We're returning to S-298, what was called the Elections Bill, and there is a draft 2.1 for your consideration posted online. Other materials posted since yesterday include the full text of the Voting Rights Act as it's codified in the U.S. Code, reorganized, as well as the majority and relevant text from the Virginia statute, which this bill was originally based on, coming from the Senate as introduced. The updated language in draft 2.1 of this committee's amendment to S-298 will appear at the bottom of page 5, breaking into the top of page 6. And just to orient the committee members, this is where we're discussing the disclosures for candidates for state, legislative, and county office. We had section 4, which pertained to additional duties being tasked to the Ethics Commission. Then we had section 5 having to do with the suspension of some various aspects of law. That is in 17 VSA 2415, having to do with disclosure requirements for those candidates. And then its sister, it's 2414, and then its sister provision enforcements being found in 17 VSA 2415. The new language will read, notwithstanding 17 VSA 2415, for the period from June 1st, 2026 to May 30th, 2027, the Office of the Secretary of State and the State Ethics Commission shall not enforce the provisions of 17 VSA 2415, nor shall candidates for the office, county office, state senator, and state representative shall be penalized pursuant to 17 VSA 2415. I see there's an extra shall in there. We'll remove that for next time. The change being that yesterday's text didn't require candidates to provide their submit their disclosure forms, and there was no enforcement for that year. This corrects it so that there's still the requirement for the candidate to provide that disclosure form. However, there are no penalties or enforcement provisions for 1 year. That's the extent of the updated text for right now. Also, I was given a little bit of homework regarding one of the cases that Rep. Stone raised, and I'd be happy to speak to that. This was in the context of the conversation of federal case law and totality of circumstances when examining what federal law has. Section 2 offenses. These are those racial gerrymandering cases there. The case in particular was Thornburg v. Gingles or Gingles, say it either way. And this is the principles inside that case were revisited in another case called Allen v. Milligan somewhat recently in 2023. Sorry. The importance of that case, what we're calling the factors or the analysis applied to these type of cases. There are 2 tests. One is a threshold test, which has 3 factors. Those are called Gingles factors, and then followed by a subsequent examination of totality of circumstances, which the court in Allen v. Milligan described as they enumerated some of those and named them Zimmer factors based on some legislative intent, really a report that was issued alongside federal legislature's consideration of the Voting Rights Act and its subsequent amendments. So happy to go through what that test actually looks like to provide a little bit of idea of how the federal courts have considered these things. So those 3 threshold considerations that must be met in order to show that there is part of the test to see if there's a section 2 violation of racial gerrymandering. So the Jingles factors, those 3 threshold conditions are that a minority group is sufficiently large and geographically compact to constitute a majority in a single member district. Second, that the minority group is politically cohesive. And third, that the majority votes sufficiently as a bloc to enable it to defeat the minority's preferred candidate. So if all 3 of those are shown, then the court goes on to the totality of circumstances test, in which examining those Zimmer factors. And yes, what proceeds to analyze whether a violation has occurred based on the totality of circumstances that members of an identified racial group have less opportunity than do other members of the electorate to participate, to elect a candidate of their choice. And let's see, the court listed, I think, just 7 examples here. And again, these are certain factors. It's a non-exclusive list, however. So the examples here they have, let's see, court could consider the extent of any the extent of any history of official discrimination in the state or political subdivision that touched the right of the members of the minority group to register, to vote, or otherwise participate in the democratic process. 2, the extent to which voting in the elections of a state or political subdivision is racially polarized. 3, the extent to which the state or political subdivision has used unusually large election districts, majority vote requirements, anti-single shot provisions, or other voting practices or other procedures that may enhance the opportunity for discrimination against the minority group. Or, and I'll just stop here after this one, if there is a candidate slating process, one of the members of the minority group have been denied access to that process. So these are varied examples of certain circumstances that either have relevance in the history of Jim Crow, or other perhaps even newer instances or examples of vote dilution, voter repression, things of those natures, but particularly in the context of reapportionment and redistricting you see here. So when we look to what we have in the bill here, we were talking yesterday about draft 1.1 from the Senate Government Operations Committee, where they actually did enumerate various examples or items that could be considered as part of the totality of circumstances. They're different than the ones I just read, but to give a flavor of those, a history of discrimination with respect to the protected class issue. So then similarity being history. Let's see. And actually, I'm thinking that some of these occurred. I have a note here, Fifth Circuit case perhaps, but I'd have to double check that. Sorry, those are the Zimmer factors. Actually, never mind. That's not what these are from. Pardon me. But the factor would be to the extent which members of the relevant protected class are disadvantaged or otherwise bear the effects of public or private discrimination in areas such as education, employment, health, criminal justice, housing, transportation, land use, or environmental protection. I'll just read one more of these. There's more. The use of any election policy or practice that may enhance the discriminatory dilutive effects of the relevant election policy or practice or method of election municipality. So these have been removed, and now we just simply have a totality of the circumstances test standards put in, and then kind of one example that remains in there. That one example and that language is kind of a carbon copy, really, verbatim appears in the federal and the Virginia law. And I will say, when it comes to enforcement of it, how will the AG's office interpret the phrase totality of circumstances? Of course, I defer to them for a much more particularized answer, but I can speak to how the courts may interpret that as well. It's a matter of they will look to, okay, what is the legislative history when they search for legislative intent? They'll look to various versions of this. They'll look to testimony. We'll see that it has been removed. They may read into that. They may not. Transcripts produced from this, or any subsequent reports coming from this committee, they'll certainly probably look at those. But they certainly very well may return to the deliberations of this particular committee and for any sort of hints, or they discount it significantly. They may also look to federal case law in the past and see, okay, well, if the committee was discussing these Jingles and Zimmer factors, is it appropriate to kind of apply those? Although I should make a distinguish here between Jingles being a threshold test and then moving on to the totality of circumstances analysis following that. That's not the Jingles threshold conditions and tests aren't necessarily explicitly, I should say they are not explicitly written into the law here. It's possible that a court could sweep it into various considerations, just knowing that there is, at least in the federal stage, commonality when it comes to analyzing what are the totality of circumstances in these vote dilution kind of cases here. Sorry. My long-winded answer to yesterday's, but I hope you find that helpful to some degree.
No, it's definitely, yeah, I found it useful. Anything for council at this stage of the game? No. Okay, thank you, sir. That takes us into our witness testimony. We're going to start off with the Secretary of State's office. And would you like to come up together?
Yes.
Yes. All right. Now that we know, thank you very much, gentlemen. That would be a great help.
Hi, how are you?
Wonderful. How are you?
Good. Good afternoon. For the record, my name is Lauren Hibbert and I'm the Deputy Secretary of State, and it's very nice to meet you in particular, sir. Yes.
Thank you so much. Thank you so much.
But yes, our newest member. Thank you for helping me do my job.
Oh,
I completely forgot to introduce the new member to you too.
I just breathed into this group.
good luck with them.
Exceptional.
I agree.
They're like the weave of a Viola shirt. Look it up. It's for gentlemen and ladies only.
Okay, well,
share that with
I
you.
think I'm precluded from being able to wear it.
Oh, no.
All right, well,
We'll see.
I'm very lucky because I'm joined by,
Sean Sheehan, Elections Director, Secretary of State. Nice to meet you as well.
Thank you so much. Nice to meet you.
thank you so much for having us on S-298. We have testified quite a bit about this bill, and I think we'll just testify to the new sections or the sections that have changed. Specifically, but again, just to affirm, we strongly support this bill. We think given the national landscape, the threat of the Supreme Court, and the fear, concern, what have you from Vermonters, this is a good first step in a larger conversation to make sure that Vermonters' right to vote, access to the ballot, access to determine who gets to speak for you in this building and at the statewide level and at the national level is protected on an ongoing basis. So with that, we also know that there's some provisions in this bill that we care about and have been added, and we're going to speak to those specifically. The first is the new sections related to the Ethics Commission's candidate disclosure form. We have been engaged with the Ethics Commission since the summer about the candidate financial disclosure form. As you all know, since you have run for office, you need to obtain your petitions and you need to fill out a financial disclosure form. Those two things are provided to the clerk. Who the clerk is differs depending on which role you're running for. We post those financial disclosures, the Secretary of State, and we tell the Ethics Commission who has not filed the candidate financial disclosure. We have for you a flow diagram that is based solely on the statute. And you can see that the tasks that are in yellow are the tasks of the Ethics Commission. The tasks that are in purple are the tasks of the clerk. The task that is in blue is the task that's for the candidate. And the tasks that are in green are the Secretary of State. Do you need
I
more?
apologize too if I.
Two more. One more.
I can give up mine.
I can.
It's
Sean and I-
posted online as well.
Oh, it's posted online, is it?
And it is, yeah.
Okay. All right, cool.
Great.
Somebody need one?
Nick, you can have this, I'll look on.
Thank you.
You're
I'm
welcome.
more of a hard copy.
You're in there.
So the candidate's financial disclosure has been a requirement in the law for quite some time. The questions of the candidate financial disclosure are the same questions as the financial disclosures that executive officers need to fulfill. So me as Deputy Secretary of State, I have to fill out a financial disclosure as an executive officer. The questions in the executive officer financial disclosure and the candidate financial disclosure are the same questions. And from the Secretary of State's perspective, the statute's very clear. The statute says, and this committee helped modify the statute. It used to say that the Ethics Commission shall prepare the candidate financial disclosure form. The executive director for the Ethics Commission testified seeking clarity on the language in the statute. And as her filed testimony last session said, because there was ambiguity about the role of the Ethics Commission, they proposed that the language be that the Ethics Commission draft the form. What this body decided was that the Ethics Commission shall create and maintain the candidate financial disclosure form. For the Secretary of State, from our perspective, we believe that the statute is clear, that Section 4 is not a change in the role of the Ethics Commission, but instead clarifies that the Ethics Commission should create and maintain the candidate financial disclosure form. Why this matters to us is we are more than happy to describe to the candidate where they file it. So if you look at your flow chart, the purple, we're happy to describe the green, what we do with the form. And we're happy to point people to the statute, which very clearly outlines the yellow, which is the Ethics Commission's duties of enforcing the candidate financial disclosure. What we are not comfortable doing is answering what tax forms do I need to provide? What assets do I need to disclose? How do I answer this question if this is my particular financial scenario? We are not experts in that. We don't want to be in the business of giving people advice on how to fill out their financial disclosure. We believe that is properly the role of the Ethics Commission. We've heard very clearly from them that they don't have staff or capability to answer those questions. Our request has been post the candidate financial disclosure form on your website. And if you can't answer questions, come up with some FAQs, provide answers to the candidates, and we'll point people to those FAQs. But we cannot answer those questions for candidates.
Representative.
Thank you. So when I was looking at what I needed to fill out for this election cycle, and didn't find the disclosure form, there are FAQs on the Secretary of State website. Would you be opposed to posting FAQs that refer to the disclosure, the specific disclosure form on the ethics website? Or would you not even be comfortable having that on your website?
So our ask is that the Ethics Commission post the form and FAQs on their website, and that we refer, if you have a question about the specifics of how to answer the questions, that we would point to the Ethics Commission. That is our strong preference.
I think I phrased that poorly. If a candidate is looking on your website, because that's where a candidate goes first, they have no idea the Ethics Commission even exists.
Yep.
Would there be something on their website that would direct them to the Ethics Commission?
Yes, absolutely. And that's why we have been asking that the Ethics Commission have this information on their website so that we can point to it. And we would indicate to candidates that they need to obviously obtain the petitions and complete the financial disclosure form. Now, this is
Sorry.
sorry,
Oh, sorry.
can I just finish my
Yeah.
sentence? This is a particular issue for us because at this moment, we do not, as a state, have a finalized disclosure form. And candidates are going to start filing on Monday. So we need to have the full window of time so that candidates who are early, which we know they're or on time, at the very beginning, can complete their whole process on Monday, Tuesday, and Wednesday of next week. If we don't have this form available to the public collectively as a state, then that puts candidates filing later, which puts an extreme amount of crunch on our office to process the petitions and the candidate financial disclosures. So that's why for us, we have really been trying to get this clarified with the Ethics Commission. If the Ethics Commission absolutely cannot provide the form, we will create the form, but we will indicate that it's the Ethics Commission's form and tell the public to contact the Ethics Commission because we cannot answer specifics about how to answer the questions. But that's really out of sheer desperation at this moment. And I want to be very, very clear. That's not going to happen on an ongoing basis because I am asking this body to clarify what the role of the Ethics Commission is. And really at this point, our back is against the wall because candidates are calling our office to say, where is this form? And this is frankly embarrassing. Like, this should not be an issue. And we should have a form available to candidates right now.
Yeah, follow-up.
Yes, so the form is not available. We don't know when it's going to be available. If we postpone, if this language takes effect and we do postpone or suspend for a year, would your office be averse to having a link on the campaign finance website or where a candidate files, a link to the Ethics Commission website?
No, Representative Pango, I think our office is always going to have to be hand in hand with the Ethics Commission so that candidates know. And I want to be clear, from the Secretary of State's perspective, we would prefer that Section 5 that the penalties not be suspended, because we think that the Ethics Commission has a really important role. And the enforcement of having candidates provide this financial disclosure is important to Vermonters. Now, that being said, I understand why this committee might want to do that because what they're hearing is the Ethics Commission doesn't have the staff to help answer questions on a form. So if you don't have staff to answer questions on the form, how do you have staff to enforce the requirement? I think is a rational question. But I do want to just make sure that we are on record saying we support this requirement. We support enforcement of this requirement. What we cannot support is our office taking on responsibility for answering questions about the specifics of the form. What happens if candidates don't file the form? We're happy to answer that question. The statute's really clear. But financial advice on what needs to be disclosed, we are not comfortable answering. And to that point, on Section 5, it says that from the period of June 1st, 2026 through May 2027, we think it would be clearer to just say for the period of through May 30th of 27, because we want to make sure that it's clear that you have to do it for this whole filing period. We want to make it very clear that when you start filing on April 27th, all the way through this year, that's required. And the other is we would ask that the Office of the Secretary of State be removed from that section. We do not have any enforcement power whatsoever in this statute. It is only the Ethics Commission who has enforcement power. We provide information to them, but we do not enforce.
If I could just, to represent Hango's prior question about adding the link to commission, that's something that is up on our site on the candidacy page. There's a place right there. We reference the Ethics Commission financial disclosure form and we provide a link to the Ethics Commission right now, and we say when the form is ready, we will provide a link from this location. But there is a link to the commission website right now. That was a change we made maybe a couple months ago. We previously had a link to the Ethics Commission's email address. The Ethics Commission asked us to remove the email because of the capacity of email. So we replaced it with a link to the Ethics Commission's website, but also made that coming soon place so that when candidates would be coming and they'd be finding the other information about the consent, about the petitions, the other packet they need, that they would know where the Ethics Commission financial disclosure form could be found on our site once it is ready.
We actually looked for it and it took quite a while to find that on your website. So I would hope that if going forward, there is the requirement to fill it out and submit it somewhere, that the link is right there next to or with the candidate petitions and consent of candidacy form. Just from a layperson's perspective, it was very difficult to find, but thank you for pointing out that it's there. The link is there. It just doesn't really go to anything. Right.
Not right now.
Right, well, it goes to the Ethics Commission's website, but not to find the actual form, correct. And also on the instruction, the petition packets too, we do have a set of FAQs of what needs to be submitted, how they have to be wet ink, all those kinds of things. And we do reference both the Ethics Commission financial disclosure as well as referencing people to 17 VSA 2415 as far as what is the consequence if they don't fill out the form. But I certainly take your point into advisement, and I appreciate it's hard to find. We'll add the location to those additional links as well.
Rep. Waters, do you have a question?
I do have a question. Can you please speak to the idea of an elected official? The Secretary of State is an elected official, so it's a political
Yes.
office. Can you speak to the conflict of having an elected official be in charge of and managing people who are managing these forms?
Yes, I thank you for that question. I think that's one of our core, besides capacity, which this committee knows well, the immense duties on our small elections division in this upcoming couple of months. Our second largest concern is having an elected official oversee the functions of what we see as the Ethics Commission's duties, because we believe that the Ethics Commission was created to be independent by the legislature, that decision to have the Ethics Commission be independent was a conscious choice of this legislature, and that it would be inappropriate for an elected official to oversee its core functions.
Okay, thank you.
All right.
So if there's no more on the Ethics Commission, I'm going to turn it over to Sean to talk about safety protections and clarity on the voter checklist.
Thank you. Again, I think so. When I was in last week, we spoke about the campaign finance provision relating to the safety protections for candidates. We heard the feedback and I think had a robust conversation. Last week was helpful to see what NCSL and others talk about other states having. I think from where we came out of that location was again back of what's been our litmus test for everything in this bill is not wanting to change election rules and procedures in the middle of an election year. And so some of the things that other states do about specifically noting what can't be spent or having a dollar cap on certain types of expenditures, we saw as being a change to the way the elections are conducted. Whereas the way our elections right now, the campaign finance law allows campaign expenditures to be acceptable if necessary to allow a candidate to campaign. So really, we would see that those expenditures on safety protections would be acceptable under current law. As I testified, just how in prior session was that was explicitly called out for dependent care. We felt it would be helpful to explicitly call out security measures, as that's an area we've increasingly gotten questions about. And so we met with legislative counsel after that testimony. We thought that the language legislative counsel came up with that's reflected here in version 2.1. We thought it was sufficient. We thought it would be helpful for giving that guidance to candidates, for empowering our office to be able to point candidates to that language, and very importantly, not changing what's we see is currently allowed under state law. So we think that language is straightforward. We think it provides clarity, and we're supportive of it.
Any questions on security, campaign finance?
Rep. Bissell.
In the testimony that we heard from NCSL, they had several states had caps that they could spend. I'd really like to see a cap on this, whether it be up to and not more than $2,000 or three. I think one state had 3,000. Most states had $2,000. I would like to see something in here for that expenditure. I don't want somebody just going out there and spending a whole lot of money in protective detail. We don't know.
Yeah, I think certainly understandable on that. I think if you work with legislative counsel, if there is language, we'd be happy to review that. I think it's not something that our office is opposed to in any particular way. I think it really more comes back to, would it be, doing that during this election time when people are already in the middle of a cycle, when there aren't those dollar caps, would that be problematic in that sense? Whereas right now, making this change to the changes just in the definitions section, 2901(7) is the definition section. So I think anything that got into more specifics or either prohibiting expenditures in a certain area as opposed to clarifying the definition and or instilling caps or maximums, that would, I think, have to be in the body of the campaign finance chapter, which again, I think long-term we have no problems with. I think there can be a lot of improvements, a lot of specificity, as we think we saw from what other states do with the NCSL presentation. But again, that being a pretty substantial change to how campaign finances expenditures, I think, are defined, and then in chapter how limits and things are set. So that was where on its face, our thought was this seemed like the appropriate change for 2026 to make this clarification, and certainly going into the 2027 session, if we feel we want to overhaul how the campaign finance is done, or not even overhaul, but make in smaller, limits and things, that would be the time.
And just to put a fine point on it, putting a cap in this area would be a deviation from how we do campaign finance. We don't have spending caps on anything else. So I think it would open a broader conversation of, should we have spending caps on mass media? Should we have spending caps on childcare? Should we have spending caps on other categories? And I think from the Secretary of State's perspective, we'd rather hold that conversation until it's not an election year.
Well, I'm just gonna object, because in this A of this expenditure, the sentence says expenditures may include those expenses that are necessary to allow candidate campaigns, such as expenses for a designated family member or that occurred while campaigning, or for the provision of monitoring system protective. That section right there is the problem that I have. Provision of monitoring systems, protective detail, and cybersecurity. That section alone could say with a maximum of up to $2,000. It doesn't affect any other part of the bill as far as campaign finance goes. It's just those activities.
Yeah, I'm not saying that we don't understand you, Representative. What I'm just saying is it's a different model, adding the cap. And in other areas of campaign finance, we don't have any caps. And so if we're going to start adding caps, I think it should lead to a broader conversation. And we would prefer to have the broader conversation, not at this particular moment.
And I think in addition to that, I don't want to speak for legislative counsel either, but I learned, I think, in our conversation that I think with really that expenditures may include, because everything after that may include is used at the beginning. Everything after that is really just a may. It's not limited. It's not exclusively to this point. So my understanding is if you were to have a dollar value in there, it would be fighting back with the may include, because it's not limited to what follows the rest of section A. Section A is specifically calling out examples. Whereas if you were to have a cap, it would require either a restructuring of the way that definition section is written, or else instilling that cap later in the actual body of the chapter that controls expenditures.
And why have section A at all?
Because of, you're talking about the expenditures for the purpose of the monitoring systems, and yeah, I mean, there is like a lot of security concerns that have come up these days. I mean, I can speak to that personally. In multiple election cycles now, I got my first aggressive threat towards violence towards me in campaign 2020. And it's continued, and I've had to put cameras on my home and other things. And as other constitutional officers, statewide positions, I personally feel if they feel the need for security detail for campaign purposes, it is unfortunately worthy. And I think putting a cap on it, quite frankly, I don't think that the cost will vary so much with what you need to do, especially within the realm of personal security detail. And it is fully disclosed on the campaign forms, so people can make judgment if they want to about how those monies are being allocated and dispensed throughout for the purpose of that. So I think that's where my end that.
Well, I mean, I'm not discrediting the security purposes of the campaign, and then nobody should be threatened. That's not my point. My point is that somebody could do a very, very expensive security system in their home with a lot of money, not win their campaign, and their campaign finance money just put a huge security system into their home. Then
I think you're speaking to a hypothetical that is.
that's why it needs to have a cap.
I'm going to disagree, because I think you're speaking to a hypothetical that's possible, but I don't want to hold back on the possibility of other people using the dollars. So this is all publicly disclosed. It is their choice to do it. People donated monies to the campaigns for whatever execution charges purposes. So and not knowing like what these costs could be, because this is a new thing. To the point of the Secretary of State's office reevaluating this next year, next cycle, we can see how this plays out now with expenditures and other things, utilize that information to make a more granular decision moving forward. But right now, I'm going to echo the Secretary of State's office position on that. Rep. Waters.
My concern about starting, Rep. Pinsto, I totally see your point. The thing that I worry about is the fact that we haven't done this in any other area of campaign finance legislation, and that if we put a cap on this, like the deputy secretary mentioned, then all of a sudden, all of these other things that people are spending their campaign finance money on is I guess the equivalent would be saying, okay, we have allowed people to use this for childcare. Can we allow someone to hire a nanny from Switzerland and use that money to fly her over here and then, work full time and live in a house that they pay rent for? You know what I mean? We don't quite have a
payer policy.
Sure. We don't have a policy for that. So technically somebody could do it, but nobody has yet. I believe people use it for a babysitter, for daycare or preschool or whatever it is. So it's just like, I see their point and I see your point too. Like it seems like something that we really think about, but once we start doing it for one thing, it's another case of these whatabouts, and it's like, what about everything else? And then it's a whole can of worms that we can't do in an election year.
And I was just gonna point out, it will change like the website when you're putting your information in for, I spent $20 on it. You will add these things, so it'll be easy for us to look back and get that data.
Yes.
To have a more robust conversation next year if we're seeing that people are spending $10,000 a person, on ADT home care, we can figure that out pretty easily. So.
And we're happy to
Back at it, it's an easy thing to look.
we're happy to come back and talk about that with this committee after.
I guess my big problem is that we're putting through a bill that is not 100%. We've got to come back to it. So if we can't do the campaign finance for everything, then I don't know, I just have a really hard time putting through a bill that doesn't, again, it's election season, which we said we wouldn't do bills during election season. We're doing a bill, and then we don't want to talk about it because it affects other parts of the bill. It makes no sense. That's all. It's,
We're gonna do a lot of work on this week, so we'll have more time to touch on this.
Yeah.
No, I'm good, thank you.
Okay,
All right, can we move to the voter checklist?
please.
So this one, spoke to last time as well. This was a area that, again, I think in the realm of not, of providing clarity, not trying to, of being in the bill, the election year, but the bill is trying to provide clarity and consistency, to not be having unclear, rules and procedures, but also not changing on the way things are done. On the checklist side was the question we spoke last time, but we just have specific language that we have in our written testimony this time. Last week, I spoke to it that we'd heard from a number of clerks with concern that while 17 VSA 2154 is very clear for how the Secretary of State's office needs to handle requests for public records requests for the voter checklist and how that should be having an affidavit for the person to sign, and they'll follow the law, not using it for commercial purposes, foreign governments, federal agencies, that the statute is vaguer, it's more vague for clerks. It forbids them from exposing the checklist to those same prohibited uses, but it doesn't stipulate a process. So that's a piece that we've been working, since last summer when it really came up, sharing our affidavit with clerks, have been adopting it. We've also heard that if they had the language in statute, that was a clear directive to them, provided that same consistency, that it would be appreciated. And so the language we provide here in our testimony, specific to 17 VSA 2154C, just making that very clear in statute, the same process that the Secretary of State's office goes through, and we get a records request, that same process applies to the clerks as well. And we think that would provide that consistency across the board.
Representatives Evans.
I think we're gonna hear from town clerk in a minute, but I just wanted to verify that you consulted with town clerks and worked with them to come up with.
We've consulted with some. I wouldn't say that we've consulted with all.
Sure.
But we have consulted with some.
Okay, good, thank you.
That was what led us to.
Yeah, okay, good.
And I think the other thing that's just fair is to say is that we have been hearing not only from town clerks, but also from Vermonters on a fairly steady basis to protect the voter checklist. And if anybody is able to go, and of course, recently it's been about the federal government protecting the voter checklist from the federal government. And we have been standing very firm on that and filing lawsuits and all sorts of things. But it's not just the federal government. The voter checklist has a lot of personal data for everybody. And that's why this statute is there. This is to ensure that it's not for commercial purposes, that it's not to be used in certain circumstances. And that's because Vermont has decided that this information should be secure. And if someone's able to go municipality to municipality and basically create their own voter checklist, we think that is a problem and an oversight in the way that this law was originally crafted, or perhaps just the opportunities for the misuse of this data was not foreseen when this law was drafted previously. So we think this is a corrective measure that it protects Vermonters' data without a huge burden on town clerks. And provides town clerks the support to say, I need this affidavit before I can give you this
Yeah, the
information.
protection, I mean, taking them out of the jeopardy. If you have a requirement not to, not to share something, but not a mechanism to share it, then you're left in the bind of potentially being, in jeopardy and at risk of breaking the law if you give out that data. But on the other hand, not having the protection of if you even ask someone for the affidavit, which we know many are doing now after sharing, which they're not stopped from doing. Current law does not, it doesn't specify the mechanism, and we've communicated that. Well, the clerk who have asked, there's nothing stopping you from doing this. You can use our affidavit as a model, but still finding that puts you in a position if it feels like to the person requesting from you that you're providing more obstacle than the law requires, and yet you're not having the protection of properly vetting it and potentially violating the law if you give it to somebody you shouldn't.
Any questions from the table?
Great. Thank you so much. If you have any further questions, we're happy to come back and testify.
Thank you so much. Yes. You're definitely committing a lot of table time to this bill this week. All right, up next, Paul Earlbaum, Commissioner, Vermont State Ethics Commission. How are you doing, Paul? It's been a little while. Yeah.
Today, hope everybody's doing just fine. And hi, nice to meet you. Hi. And for everybody else, you'll know that I've been here before, but record, my name is Paul Earlbaum. I'm the chair of the Vermont State Ethics Commission. And I'll skip my autobiography unless you really want to hear it. And so just really thank you first for inviting me to testify. And I'd like to relay a message from Jim Condos, our prior Secretary of State, who is now our newest commissioner on the State Ethics Commission. I invited him and our other commissioners to attend today. None were able to. I heard from Jim asking me to relay a message to you folks saying that although he is not able to attend today, he would welcome the opportunity to address you in the future, especially about this bill. Just tell me if you'd like, Jim. In a conversation I had with Jim, it was day before yesterday, I told him the argument that you just heard from Lauren Hibbert, that the Secretary of State, as an elected official and affiliated with a political party, is not an appropriate person to be advising on how to fill out this financial disclosure form. Jim Condos completely disagrees with that. He said he never had a problem with that. And he thinks the concern is overblown. Frankly, I do too. I don't really see any reason why the election division of the Secretary of State's office couldn't continue what it's been doing for years, answering candidates' questions. I've been here before. I've told you before, we don't have the staff to do what's already been assigned to us. We've already put on the homepage of our website, says we cannot provide municipal services to towns because we don't have the staff. This would be yet another thing that we simply cannot do. Maybe I should have been clear from the get-go. I'm only addressing section 4 of this bill. The part that directs the Ethics Commission to provide candidates with information and advice about financial disclosure law. I'd like to take a little step back. Lauren correctly said that before Act 171 kicked in a couple of years ago, the statute said that the Ethics Commission will prepare this form, the financial disclosure form. That led to some misunderstandings, people calling us saying, oh, you're going to help us prepare the form. No. So our executive director, Chris Sivrit, in Senate GovOps, government operations, talked with them about that. And Senate government operations created the new language that instead of the word prepare, it will say create and maintain. And create, that's clear. We'll draft it. All right, you want us to do it, we'll draft it. maintain was intended solely to mean that when there were legislative updates, statutory updates, the Vermont State Ethics Commission would modify the form. I was not present, so I'm getting the secondhand from Chris Sivert. She said that was made clear that there'd be no additional duties given to the Ethics Commission. Haven't been doing it, and it wasn't intended. So when this question came up, I wrote to all 2024 members of the Senate Government Operations Committee and asked, so what's your memory of the legislative history? How do we get to create and maintain? And what does maintain mean? I heard back from Senator Ruth Hardy, who said she discussed this with the other members of Senate GovOps from 2024. She discussed it with Legislative Council. And what it meant was that, people ultimately could ask questions of the Ethics Commission, but the Ethics Commission would not be required to respond. So basically maintaining the way it has been. This is an altogether new assignment for the Ethics Commission that doesn't have the staff to do it anyway. All right, let me look at my notes and see what, by the way, we do have TJ Jones. Yes, we do. I hope you'll hear from him. TJ, you've heard from before. TJ is a nationwide, well-respected expert in state ethics commissions. He can talk to us about what other states do with regard to mixing ethics commissions with electoral candidates in politics. Just looking at my notes. So as already mentioned to you, we already struggle to provide timely responses to questions from and about state public servants. We have one half-time executive director, one half-time administrative assistant. And by the way, I haven't seen the chart that Sean and your friend handed out, but from the oral description, thank you. I'll see it on the website. From the oral description, it sounded different than our understanding because, again, we've never done this task that would be assigned in S-298. My understanding, and folks from Secretary of State's office, please correct me if I'm wrong, with only one exception, I believe that the Secretary of State's election division takes care of just about everything to do with elections. The one exception is that the Ethics Commission creates this financial disclosure form, but otherwise Secretary of State's office has and continues to do everything else regarding elections. Correct me if I'm wrong. So if the legislature expressly assigns this election-related duty to the commission, we'll only be able to implement it if we're given more staff. We've already requested 2 additional staff. And well, I'm going to take a segue, and I think I did. I mentioned it in my written write-up, So the big bill, the budget bill, did something unusual. It not only provided, unfortunately, only one attorney, but that was sweet, one attorney to the Ethics Commission, not enough, but a nice tip of the hat that, okay, it's not in the right direction. Although that one attorney's duties were constrained to be primarily municipal work. But the bill also, to me, strangely, also assigned us yet another duty to create a handbook for, to basically, to put the ethics, the state code of ethics into accessible language. Now, some very large states with very complex ethics codes do have a handbook. But we're a relatively small state with, compared to other states, a relatively simple set of ethics code. So what really works, and what we've heard from other state ethics commissions, and TJ Jones can address this too, what's most important for an ethics commission is to do in-person trainings with people. And going to conferences and speaking with folks from other state ethics commissions, they're very clear that training is the most important. Second on the list of priorities is informal resolutions, and then investigations are third on the list, and fourth of their priorities is enforcement. But they don't want to get to enforcement. They want to get to training so that there are less ethics violations, and so there are less ethics complaints. And if we had the staff, we would love to do more in-person trainings.
Hold on one second, while I think I have.
I was thinking, can we kind of like focus on the form and
Yeah.
whereabouts
And-
and sort of who's responsible for delivering that to whom?
Thank you, member.
I'd be glad to address that. So months ago, we provided the Secretary of State's Election Division with a revised form. There was a change in the statute, just like the statute says, we maintained it, we updated it. I think it was in January, we sent it. They have it. Just within the last couple of days, I updated the FAQs. And I can mention that because I believe that it contains an interim solution to this kerfuffle. We have hesitated to post the form on our website because we don't want people to think that we're in charge of answering the questions. We haven't been, we don't have the capacity to. So we don't want to post it on our website. If, you know, I mean, we could yield on that if both the Secretary of State's office and we both post it. And then if we end up getting calls, we could say, consult a private attorney. And this was the interim solution I've suggested in the FAQs, just basically saying neither the Secretary of State's office nor the Ethics Commission is able currently to respond to questions about this form. If you have questions, contact a private attorney. If you need to contact a private attorney but don't have one, here's the phone number for the Vermont Bar Association Lawyer Referral Service. Go ahead.
Popping up here as well. I'm gonna start with Rep. Waters Evans, and it looked like this, and I'll hang over, read the hands correctly.
Thank you for coming. So here's my question for you. I mean, I have a couple, but my first one is, it sounds like, and it's really clear to me that you are having some struggles and don't have faith in your ability to actually answer the questions that people might ask. This is what I'm understanding from you, but that you do already have a form that exists in some way.
Oh, yeah, we've submitted it months ago.
Okay. Now, is that like ready to be posted online, or is there
Yes, it's PDF fillable
is there a
online.
good, clean copy? Everything's,
Yes.
yes.
Absolutely. Been in their hands for months.
Okay. All right. And the next question is, and you have an FAQ document for, questions that people might have. You've already created this?
Yes, they've, for months as well, had one with 3 FAQs, frequently asked questions. Just the other day, I submitted to them a suggestion for 2, or actually 3 more, I believe, FAQs, yes.
All right. Well, this is good news, I think, because it seems like if we have a form that exists,
Yes,
like, fulfills these statutory requirements, and we have some answers to questions that people might have already.
yes.
Maybe, it might be being too optimistic, but maybe that document or, those questions would help people from having to call and ask for further advice, right? And to ease the burden on you. So I guess my question is, if we are like so almost there, we've got this in sight here, and we do have a deadline that's coming up in not too many days from now.
Understood.
So then I guess what I would say, like, what do you need? Like, what kind of compromise is appropriate or would be available to you and your staff, or to, like, where's kind of that line between maybe nobody gets exactly what they want, but there's a middle ground that could work for everyone?
Understood. And forgive me, I'll be repeating myself. I included it in the latest round of FAQs that I proposed. It was number 6, last on the list. Just basically a statement, neither the Secretary of State's office nor the Ethics Commission is currently capable of responding to your questions. If you have questions, contact a private attorney to ask your questions. If you don't have a private attorney, here's the number for the Bar Association's Lawyer Referral Service. that's, I mean, we simply can't. I'm not being stubborn. I'm just saying, we don't have this, we just can't do it. And Lauren and Sean have said, frankly, they don't have the staff either, that they're already pressed. So if that's the situation, to me, it seems only reasonable that we both say, we can't do it. Contact a private attorney.
I got pissed off, Pango Stone.
Yes, my question is, why is the form so difficult that you would need assistance? I mean, it's pretty straightforward, if I remember correctly.
I think so too. You know, the questions in the past that have come, but we've only had a few candidates rather, contacting us. And those few questions have mostly been, what happens if I don't submit this form? And the answer is, as you know, probably, that you can still get on the ballot. You know, the public will know that you didn't submit the form. And most recently, you are liable for a financial penalty. That's new. Yet another unfunded mandate, something we don't have the staff to implement, but we haven't gotten a request yet. Does that answer your question?
Yes, it does. Thank you.
Pango.
So I know I saw on the Secretary of State's website, I can't find it again, a link to the Ethics Commission.
Mhm.
And then when I'm on the Ethics Commission website and, sorry, wrong tab, Ethics Commission, under financial disclosures, it says who needs to file a financial disclosure form, candidates for state and legislative office. It says that these forms, along with filing instructions, are available on the Secretary of State Elections Division webpage. So you're both referring each other to each other. There's no form. And if there were a form that you have designed, why would you not be able to answer questions about the form that you designed?
Because we don't have the staff to do it. We're already trying to respond to requests for advice, requests for guidance from state units, from state public servants. We're, Chris Sivert, our executive director, and if you have questions about why she's on leave of absence, I'd be glad to address that. But our executive director, I'm sorry, I forgot
That's okay.
my train of thought. I was going to
Telling
say,
me it's about time.
yeah, oh, I know
It's
that.
personnel time.
Yes,
It's not because you lack the expertise to answer the forms. It's the time. Because you all designed the forms, so you must know what you're asking.
yes, and we'd be, absolutely, the language of the form that we drafted, we'd be glad to answer questions about. In years past, my understanding from Chris Sivert, our executive director, is that somebody from the elections division would call us. She said this happened like 2 or 3 times and said, would you clarify whatever the wording was? And then that person from elections division got back to the candidate. What I was going to say a moment ago, and forgive me, because it's about not having enough staff. Our executive director has been working more than full-time for half-time pay for several years, going on 5 years. That's just one example of, you know, we just don't have the staff to,
Okay,
right?
understood.
Sorry.
It's personnel time that is constraining you at this moment, and we will hear from your executive director tomorrow morning, I believe.
So I heard, that's wonderful. Thank you.
Rep Stone.
I was just wondering if you could speak to some of the information that I've done research on from the Campaign Legal Center and Bipartisan Policy Center, saying that it's widely considered unethical for an elected official to oversee a form like this, just to, you know, an inherent conflict of interest, appearance of corruption, political self-interest, all of those things. Number 2, I want to just say aloud that it's already really prohibitive to run for office, especially in a state where our legislature is one of the lowest paying in the nation. We don't have office, we don't have staff, we don't have healthcare insurance. So the assumption that we could hire private attorneys is wild. You're going to see way fewer people, especially way few people who look like me in this building, if that's what it takes to run for office, is hire a private attorney. So don't like that idea. And then I was just wondering, because you are the ones who created this form, if you feel like it's too complicated or it's something that's going to require a legal professional to be able to read and parse through, couldn't you just make it simpler? Because you kind of like the master of your own destiny. So I'm wondering if you're like, whoop, this is too complicated. It's going to usher in a bunch of questions. Could you not just make it more simple?
I'd be glad to respond to that. I think it's already simple. I don't think that we're getting particular questions about what does this mean? What does that mean? What we are getting, again, the few questions that have come to this office and that have also come from executive officers, basically the question, what happens if I don't fill out this form? As Lauren mentioned, the two forms are essentially identical, just the heading is different. Candidate form, executive officer form. The questions are identical. And I'm repeating, I think really rather simple to understand. I think the FAQs that we're adding this year, that I have added this year, should clarify and answer maybe most of the questions that might come in. So, and if I could just take a step back to Representative Hango's comment or question, do we feel qualified to respond to these questions? Certainly we feel qualified to respond to questions about the language of the form itself. We created it. The questions about candidate qualifications and anything else having to do with their elections is just outside our ken. It's within the bailiwick of the Secretary of State's office.
Yeah, we got hands popping up. I got a question. I'm on the Ethics Commission's webpage right now, and it's directing me to the Elections Division webpage for the form. Where is the form? I want to look at the form. The most current incarnation of the form.
We said they didn't post, they wouldn't do that.
We would prefer not to post it because we don't think questions should be coming to us. I see Lauren wants to say something. So I
would love to give the table over to the Deputy Secretary of State.
So I just want to be really clear to the committee. We don't want the Ethics Commission to answer questions about petitions or the process for filing your petitions or what is a valid signature on a petition. We don't want that. What we want the Ethics Commission to answer is, how do I answer this question on the candidate financial disclosure form? And I think it's very simple for a candidate to know, I need to ask these questions of the Elections Division and these questions of the Ethics Commission. And we're happy to say to a candidate that it sounds like you're asking a question about the form itself. You need to go to the Ethics Commission. If you're asking us what happens if you don't file the candidate disclosure forms, I think the Ethics Commission can answer that question. I think the Election Division can answer that question. The statute answers that question, quite frankly. It's not complicated. But how do I answer this question about my responsibility to fill out this form candidly and truthfully? And I have a complicated tax situation. That is not the Elections Division's responsibility. That's the Ethics Commission's responsibility and knowledge set. If it's how many signatures do I need on my petition? What constitutes a clear signature on a petition? How do you review a petition? Where do I file a petition? That's us. And we're not asking the Ethics Commission to get into that water at all. And I've said this to the commission very clearly. We don't want them to answer questions related to that. We don't want them to give elections filing advice. What we want them to do is answer questions about the form that they are responsible for and are responsible for enforcing under the law.
Thank you. And I have a couple of members who have questions. We're going to start with Brett Boyd, and then we're going to go Hooper, and then we're going to Waters Evans. I do want to be conscious of time because we have a lot of other witnesses. I have chairs meeting at 4:30. We will have Director Sivert in tomorrow. We can continue this Q&A then. But I want to be respectful of the questions that members want to ask now. Brett Boyd.
So it sounds like we have a form ready. We have an FAQ just about ready as well.
already.
Yeah. Wondering if you can speak to more so the language of the bill where we're looking to suspend the disclosure penalties for candidates in section 5.
In section 5, Again, whether it's suspended or not, we won't be in a position to enforce it. Maybe that's the best answer. So, you know, I respect Lauren Hibbert's position that it should not be suspended. And, you know, at least that puts it maybe a little fear in the heart of somebody who's not planning to file full of everything that they should. But you know what, because we can't really enforce it, I feel neutral about it.
Hoover.
How soon could we get that form in front of us? To be minutes?
Minutes ago, I proposed, and I think this would be fine. I think, you know, both the Ethics Commission and the Secretary of State's office could post it. Why not? You know, and if we get questions, if the Secretary of State's office wants to, you know, if it's about the language of the form, I or somebody will be glad to respond. But more general questions about qualifications and all this sort of stuff, we're going to say we can't respond to those kind of questions. And, you know, contact the private attorney unless the Secretary of State's office is willing to handle those questions.
So if I were seeking to have a printout of it,
Yes,
could that happen like today or tomorrow?
I suspect so. I mean, again, you know, I'm not a tech person. I don't know how to post, but
Well, if there's a
people
PDF,
do.
very quickly needs to be printed.
Absolutely.
So I'm gonna go to Rep. Waters Evans, and then we're gonna move on to the next witness because we have the Ethics Commission coming back tomorrow.
Yes, they are coming back tomorrow, just while we are on this and
So
discussing it
you
now.
got this now.
Yes, I got it. So
In circles. Okay, folks.
Secretary of State's.
Yes, okay. Hands for questions. Hands for questions. Rep. Waters Evans is asking the question of the witness.
So I had a question and then I had a comment. And my first question is, so how many, you don't currently have posted on your website that people should call a private attorney, do you?
No.
Okay, you're just saying that you would do that.
I would do that.
Okay. All right, we can discuss that before it happens maybe. But so my question is, how many questions would you say you get? Can you estimate how many questions you get usually about financial disclosure forms?
We've gotten very few, but because the law has changed and things are kicking in this year, I expect that there will be many more
Okay.
calls.
So I guess my question is, you get few questions and with the full understanding that you are in a bind right now, your executive director is on a sabbatical and you don't really have anyone to do the work, which is maybe seems to me partly like a staffing issue and partly not having enough staff and partly just the staff that you do have isn't available at the moment, which is like a different issue probably.
Glad to address that, but go ahead.
Oh, no, that's okay. We're going to hear from her tomorrow. We can talk to her about it. But so I guess my question is, how are you gauging how you're not going to have time to answer questions if you already get few questions about it? Understanding that it's going to be election year, people are going to start filling out and filing forms next week and there will be an uptick in it. But I guess I'm saying, how do you know that you're not going to be able to handle it?
Because I don't have the number of the law in my mind, but there's a change as of this year. More people will be filing and it's a new form. So I'm guessing that there will be more inquiries.
Sure.
I don't have a way to gauge it yet.
Okay. All right. So I guess.
And for that matter, it's just not our bailiwick. It's not an area of questions we've responded to in the past beyond the language of the form itself.
Yeah, I guess this is where I'm getting stuck a little bit, is that it seems like, to me, like, you know, we do have more testimony to hear, and I'll stop in a second.
No.
But like, we do have more people that we need to hear from, but it just seems like there's a fundamental disagreement right now between Ethics Commission and Secretary of State's office about who's responsible for this. And it seems to me like we've gotten to the point where it's up to the legislature to decide, because correct me if I'm wrong, but when I said what kind of compromise would work for you, I'm not quite sure I got like a solid answer on that.
Oh,
And it would just be good to have like something that we could start with that would be acceptable to you if this decision is left in our hands.
and what I propose, and forgive me if I was not clear enough, that Secretary of State's office and the Ethics Commission both promptly post that form, complete with the FAQs. Whether or not it includes consultant attorney, but, you know, and maybe just to say, the Ethics Commission is not prepared to respond to questions at this point in time,
Okay,
unless they have to do with the language of the form itself.
all right, that's, okay, so can I,
Yes,
just
go
one
ahead.
last thing and then I'm done, I swear. So it seems to me that, forgive me, but that doesn't seem like actually a compromise. If we said you need to do X, Y, Z, if we said, let's just say, for example, you both post the form, you both post the FAQs, and then if someone has a further question, it's really now, I think that our job is probably just to decide who has to answer that question. And so if we say the Ethics Commission has to answer the question, I don't know, I guess I don't think it's okay or appropriate for the Ethics Commission to say, even though we are required by law to answer these questions, we are not going to do it. But that seems to me like a tricky spot to put us in right now, to say, if you present a compromise, it doesn't matter to us because we will not compromise. Like, do you see how that is difficult on our end, or at least on my end?
I totally understand, but at
Yeah.
the same time, we've already done that with municipal services, just saying, we can't do it.
Yes. Okay.
We're gonna have plenty of time to speak with the Ethics Commission more tomorrow. I'm gonna use a little chair's prerogative right now, and
Mhm.
I saw a hand come up from Deputy Secretary of State. Did you have something here?
Yes, I just wanted to say that we're sharing the form as we received it from the Ethics Commission, your committee assistant, so that the committee can see it. Providing that technical advice. And what you'll see is that the form has the questions and the blank spaces for someone to provide the answers. It does not have any information about who prepared the form, where to direct questions about the form. It does not say the Ethics Commission at the top of the form, and it says draft on it. So we do not feel like it's ready for posting at this moment. If we were to post it, it would need a lot of, or not a lot, it would need to identify whose form it is, what form it is, and where to get answers to questions, perhaps the FAQs. But it would require some work. It was not ready for posting at this.
And if I may respond, in years past, that's just what we've sent to the Elections Division, and they have modified it to say candidate disclosure form, just the basic, very simple modifications. And then they included it in their candidate packets. So this is a new task that's being given to us.
Yeah, we will pick this up more robustly tomorrow.
Is there any time now to catch TJ Jones? No. Okay, sorry, TJ.
We'll put them on the punch list for tomorrow.
Mhm.
All right.
Thank you, folks. Thanks for hearing me out.
Yeah.
Sorry, we're.
All right, next up, we got Carol Dodge. Carol, how are you doing?
Good afternoon. I'm doing well. How about all of you?
Not bad.
Good.
There was a cheerful good.
Aggressively so.
There we go. For the record, I'm Carol Dawes. I'm the Berry City Treasurer, and I'm chair of the Legislative Committee for the Clerk and Treasurers Association. And I know that you're running low on time, so I do want to just take up three quick points. First of all, we appreciate that the new draft has removed the language that we found concerning associated with intimidation, which was really subject to interpretation and very subjective. We appreciate that language is no longer in the bill. It does still include the language that adds to the definitions of protected class, the phrase membership in a language minority group. And our big concern with that is not so much providing those protections. We fully believe in providing those protections. Our big concerns is how does that roll out? How does that, how is that actually done? will there be a requirement? I'm sorry, did you have a?
Yeah, I think Rep. Waters Evans had a question.
Yeah, did you, I don't think we did remove the intimidation section.
It's not there.
I'm just.
Not there.
I'm looking at 2.1 and
Yeah.
I don't
Yeah.
see
Not there anymore.
the word in there.
Intimidation.
What line, page?
I just searched the whole document for the word intimidation.
Okay, well,
And council has left the room.
Carol, it's on page, if I may, page
Please.
4, line 15.
Okay,
Actually,
but
line 16, it says, or recklessly intimidate.
That does, yeah.
but it's right, but it's the whole section associated with penalties upon officers has been removed. And that was the section that it was in that we were concerned about. Sorry, I wasn't clear about that.
Yeah. Yes.
Oh, okay.
That section did get removed.
Yeah.
That was-
Sorry, I wasn't clear about that.
It was then, yeah.
okay, thank you. Sorry, I just got confused for a second. I was like, wait, we didn't remove that. Okay. Carry on. Sorry, Carol.
So with regards to the membership in a language minority group, we're just concerned about how that goes into effect and how that might impact the actual duties that clerks and election workers have to perform with regards to, you know, changes to voter applications and warnings and materials and interpretive services and you know, training and funding for the actual practical applications of that language and what that might look like. And the fact that the language is in there just seems to open it up for interpretation with no guardrails. So that is something that we continue to have some concerns about. And the last thing we wanted to mention, and I was happy that Lauren mentioned it, is the language that the Secretary of State's office has proposed for 17 VSA 2154 that would help clarify the process for municipal clerks with regards to municipal voter checklists. It really does give good guidelines to municipal clerks on how to respond to those public records requests, and we would fully support that language.
I got a hand from Rep. Hango.
Thank you. Thanks, Carol. Thanks for bringing up the question about the membership in a language minority group. Are you concerned that if you don't offer multiple languages at a polling place or materials in multiple languages, that you will be in violation of this statute? Is that what the clerks are concerned about?
That is, yes, that is what the concern, you know,
Right.
The concern is, what does compliance look like? And how do we afford it? How do we gear up for it? How do we train for it? How do we determine what languages are the right ones? There's just a lot of open-ended questions.
Okay, thank you for bringing that up. I hadn't thought about that part of that sentence, but we can certainly speak to council about that.
Rep. Waters.
I just wanted to clarify, is that section that we're talking about with the language, that is something that came from the federal language, correct?
I think so, yeah.
Okay.
That's what I.
Yeah.
Yeah, this is in section 2. In the definitions and the vote denial or delusion. So, yes.
Yeah, okay.
Rep.
Thank you.
If I remember correctly, the Attorney General's office, when they were testifying about that section, I think that they said that the federal language has a lot more parameters around it so that it's easier to comply with, that they could work with us on or develop that. If we have time to do that before
Yes,
this goes out.
that was when.
And there was additional language in the original version of the bill that has been stripped out as this bill has been sort of narrowed down for this particular session. So I don't know whether that might be something that could be reviewed. So in conjunction with the Attorney General's office. That's it.
That's it? All right. Mr. straight to the point. Thank you, Carol.
I tried.
Any other questions while we have her here? Yeah, I know she's a frequent flyer, so. All right, seeing no hands. All right, thank you so much, Carol. We'll definitely reach out to you if we have any other thoughts or things we want to bounce off you.
Thank you very much.
Awesome. All right, up next, we have Heather Thomas, Executive Director for Vermont Progressive Party. How are you, Heather?
Good, how are you?
Not bad. So, yeah, we were just having the executive directors from the three major parties in to just offer insight, perspective onto the bill itself. But obviously, one of the conversations that's been really focused on today is the disclosure form and also the candidate security expenses. I almost slipped into cannabis there for a minute.
Great, thank you for having me. Good afternoon, members of the committee. I prepared a few remarks that I'll just share with you in general about the bill, kind of where it started and where it is now. So voting is one of the most significant freedoms in American democracy and is a fundamental First Amendment right guaranteed to its citizens. Sadly, it took generations for us to guarantee the right to vote for certain populations. Now is not the time to move backwards. Democracy is on the line. In this moment, we know what is at stake if the current administration has their way. We appreciate the spirit of the Vermont Voting Rights Act. This act is essential to protect Vermonters' right to vote. As we know, the Save America Act is a threat to democracy, and if passed in the Senate, will likely disenfranchise millions of Americans by upending ongoing primary elections, as requirements would come into effect immediately upon signing the bill into law, effectively ending vote-by-mail processes, including in states that already have similar voter ID laws in place, creating obstacles for voters who need to register or update voter registry where their current name does not match their name at birth, disenfranchising voters, especially rural voters who are less likely to have a passport, requiring states to submit voter registration lists to the Department of Homeland Security for verification. The Secretary of State in each state is responsible for ensuring access to voting for all eligible voters. Sending voter registration lists to the federal government is not part of the responsibility of that office. At every turn, we are bearing witness to the ways the federal government intends to interfere with upcoming elections. Our United States postal system has been compromised with changes in the location, manner, and time of outgoing mail when outgoing mail is postmarked. There are very serious consequences for the many methods to disenfranchise and challenge voting rights and invalidate ballots and votes cast. The Vermont Progressive Party believes that much of the spirit of the original Senate bill provided a more comprehensive approach to protecting voting rights in Vermont, though it left out a critical protected class. The current version in the House is a skeleton of the original bill and is now titled Voter Protections Act rather than Voting Rights Act. One significant feature that needs to be added into the bill is the recognition of the serious structural disadvantages people living with disabilities face in both registering to vote and voting in Vermont. Vermont ranks 49th in access to the ballot for people with disabilities and 50th in the nation for the voter turnout gap for disabled voters. Language needs to be added to classify Vermonters living with disabilities as a protected class under definitions. To spell out protected class means a group of citizens protected from discrimination based on race, color, disability, or membership in a language minority group. Title II of the Federal Americans with Disabilities Act provides all people with disabilities an equal opportunity to participate in all services, programs, and activities of state and local governments. Voting and meeting access is a huge cornerstone of this. This is further underscored by 4 other federal laws, including the Federal Voting Rights Act. As previously shared by Laura Cushman, staff attorney at Disability Rights Vermont, The disabled community is one of the most underrepresented groups in our society, and they deserve equal access to voting rights as their peers. Bless you. Vermont's VRA will address systemic barriers that prevent fair and representative participation in democracy. Laura was referring to a previous version of the Senate bill. The legislative priorities of the Vermont Human Rights Commission included recommendations for universal Australian ballot and universal hybrid meeting access for local elections. In my document that I'll send to you, I also have included some draft language for that to be included. We encourage all members of the committee to review the Disability Rights Addendum to Act 133 Working Group Executive Summary Report, which I will also include. There are other features that were included in the S-298 as introduced that should be reconsidered. Vermonters need to have access with language assistance to vote. Voters over the age of 65 should have accommodations at polling sites. There should be a private cause of action for voters who are intimidated, threatened, or coerced by another person. Section 2853 of S-298 as introduced regarding communication of false information to registered voters should be included. We would like to see the House work to include additional protections in this legislation and work with the Senate Judiciary Committee to include language from H 541 originally introduced by Reps. Goodnow and Nugent. Respectfully, as written, the Voter Protections Act of 2026 has been diluted and needs to be rewritten to guarantee voting rights for all Vermonters and protect Vermonters at the polls. Thank you.
Any questions for our guest? All right, seeing no hands. No, thank you very much. Oh, I'm sorry, Rep. Nugent. There we go.
I just want to clarify, did you say that disability is not a protected class in Vermont?
It is not a protected class in the bill.
If it says protected class, I think, I guess this may be a question for Tim, but it would assume, I believe it is a protected class in Vermont for housing.
Under the definition section here, it says protected class means a group of citizens protected from discrimination based on race or color or membership in a language minority group. That's what the definition section says.
Yeah, that's a question for council. Yep. Yeah, tomorrow. Anything else?
I would just encourage you all to, I can also send this along, to look, you can look at the town by town voter participation and the methods used for voting in those towns. A lot of town meeting day in particular has a very low rate of attendance.
Oh, I'm sorry, you just got a little glitchy there. We lost you.
To sort of like include, yeah, the voter participation it varies by town, but also the methods of voting vary by town. Some things are floor votes in some towns, some things are ballot, universal ballot. In my town, we have a meeting the day before town meeting day, and then the following day, we have a universal Australian ballot for all ballot items. This is obviously one small piece of a much larger discussion about voter rights, but I thank you for your time, and if there's any other questions, happy to answer them.
In no hands? All right. Thank you so much.
Thank you.
And we will move over to our next witness now. We have Executive Director, Vermont Democratic Party, May Hanlon. How you doing, May?
Doing well. How are you?
Please join us.
Thanks, everyone. Good afternoon, Chair Byron, members of the committee. My name is May Hanlon, and I serve as the Executive Director of the Vermont Democratic Party. I'm here to testify on S-298, which is now titled the Voter Protections Act of 2026. I want to be clear from the outset that I'm not here as a partisan. The right to vote is foundational for everything else that we fight for. And that's a principle that belongs to all Vermonters, regardless of party. Vermont has long prided itself on the strength of its democratic traditions. We have high turnout. We have a Secretary of State who has consistently made access a priority. We have an Attorney General who stood up for Vermonters' right to vote, and we should be proud of that. But pride in what we've built shouldn't make us complacent about the threats that we're currently facing. At the federal level, the Voting Rights Act of 1965, which is the law that Dr. Martin Luther King Jr. helped bring into existence, has been systematically weakened with a series of Supreme Court decisions and the Trump administration pushing aggressively to restrict mail-in voting, cut election security infrastructure, and demand sensitive voter data from states. We can't assume that the protections that have held for 60 years will simply hold for 60 more. In recent years, Republicans have systematically rolled back voting rights. Under Donald Trump's watch, his extreme Supreme Court has led the charge to gut the Voting Rights Act, empowering Republican elected officials to purge voter rolls and pass laws that make voting far more difficult. We've witnessed MAGA Republican attacks on election officials and infrastructure, their spread of disinformation, and the endless pursuit of countless failed lawsuits to overturn secure elections. He refuses to accept the 2020 election results. He incited the January 6th insurrection. He's repeatedly claimed that after November, we will not have to vote again. And this follows years of Republican efforts to create unnecessarily harsher voting restrictions. Our own Secretary of State was actually in federal court fighting to keep the administration's hands off Vermonters' personal voter data. The Attorney General is defending her, Vermont law is on her side. But what makes this moment very clear is that the threat to our elections are not hypothetical. They're active, they are ongoing, and they require a response. Draft 2.1 is a meaningful step. The new voter and election official intimidation provisions are broader, and they explicitly protect public servants and election officials, not just voters. And in a moment when election workers are being threatened and harassed across the country, that matters. I understand that this bill has had a long road and that the legislature has done real work to move it forward. And let's agree that this is the beginning of that work, not the end of it. The foundation that this draft establishes is strong and deeply important. Like I've talked about, the protections for election officials and voters. We're living in a moment when those workers across the country are being threatened, harassed, and driven out of public service. Election officials are doing this work under conditions that would have been unimaginable 10 years ago. Protecting the people who run our elections is foundational. You can't have a functioning democracy if the people responsible for administering it are afraid to do their jobs, if the voters are scared to go to the polls, or if people are uneasy to put their names on the ballot. So that work that the legislature has done thus far has been very meaningful, and I believe it is right, and we should be proud of it. We've heard a little bit about Louisiana v. Calais. And no ruling has come down yet. It would very likely come soon. And I'm concerned about what a bad ruling would mean for our country. Because the federal backstop in the VRA that we've relied on for decades may not be there. Now, I'm not asking this committee to solve Calais today. I'm asking it to be aware that the conversation for what we're going to have to do may become significantly more urgent. So let's not wait too long to have the rest of that conversation. The Secretary of State has demonstrated a genuine and sustained commitment to improving voter protections in Vermont, and that commitment really matters. Vermonters should feel confident that the person responsible for administering our elections is paying attention, is fighting for them, and is not going to let Washington's dysfunction become Vermont's problem. We saw that commitment on display when she refused to hand over Vermonters' personal data, and that is the kind of leadership that this moment requires. The core goal here is simple: Vermonters should feel secure that they have access to their elections. They should know that no one will intimidate them, mislead them, or make it harder for them to participate than it needs to be. And I believe that this bill moves us closer to that goal. It's a real step in the right direction, taken at a moment when steps in the right direction are not something that we can take for granted. Now, I want to speak specifically to the candidate disclosure and security provisions that are in sections 4, 5, and 6. I think they deserve more attention than they've maybe gotten thus far, and I have a direct stake in them as a party leader. So on section 4, the candidate disclosure section, I support the goal of this section. The candidates need to know their obligations, and the State Ethics Commission providing guidance or answering questions or helping candidates navigate the disclosure process would certainly be very valuable. If someone could answer questions about the form that they have to fill out, that would be awesome. And as someone who works with candidates every day, I can tell you that confusion about disclosure requirements is real, and that is also not partisan. It affects everyone running up and down the ballot. I want to flag a concern here that I know others have raised, that there has been considerable disagreements between the Secretary of State's office and the Ethics Commission about whose responsibility the form actually is, who creates it and who hosts it, and thereby who answers questions about it. That disagreement needs to be resolved before this section can work the way it's intended to. Candidates can't be held to a standard that the agencies responsible for it have not agreed on. And if there's no resources available to them to figure out what that standard is. And I believe from my reading of past law that that responsibility largely rests with the Ethics Commission. It's my understanding that the Ethics Commission has to prepare and maintain the form. And they have enforcement authority. And it is therefore the logical conclusion that the Ethics Commission owns the form. If they make the form, if they update the form, and then they enforce the standards, they should answer questions regarding the form that they put together for everyone and also host. So I also want to respond to some things that we've heard in previous testimony today, if I may. We've heard that the solution of the Ethics Commission is to tell my candidates to consult a private lawyer. I'm going to be candid. That's a wild recommendation. Recruiting candidates is already incredibly difficult, especially for young people. You know, Mary Catherine talking about people that look like us in this room, telling them to get a private lawyer, to have someone to answer questions about the form that the Ethics Commission is already required by law to make and maintain. That seems kind of crazy to me, but maybe I'm an outlier. So in previous legislation, as we've established, the Ethics Commission has to draft and maintain the form. And you just heard from the Deputy Secretary that the version of the form as it is right now apparently says draft on it. And they're trying to form modifications to the Secretary of State's office. So from my reading of what has been previously established already, that sounds to me like it runs afoul of what has already been laid out before them, given that they have to create and maintain the form. So why would the Secretary of State's office have to update the form before they can post the form? And I would also ask this committee to ensure that before this bill moves, there's real clarity about which office owns this process, because candidates deserve to know. And as a party leader who has to help them navigate it, I need to be able to point them somewhere with confidence. And right now, I can't do that. And that's a problem. I understand the legislature's prerogative here. I also want to talk about Section 5. I want to be direct that suspending disclosure requirements is not in the best interest of Vermont voters. Disclosure requirements exist for a reason. They're part of how the public knows who is running for office and whether candidates are meeting their obligations under the law. And I believe that the Secretary of State does not have enforcement authority under this section of the law in relation to the disclosures. So that belongs elsewhere. And from my reading, that belongs with the Ethics Commission. So the principle still stands, right? It's already in law that they own enforcement. And I'm quite frankly shocked that they said they would not enforce it, regardless of what happens in this room. I do think we heard that earlier, and I want to call that out because that also seems kind of crazy to me. If we're suspending penalties because the system is confusing, or if the form is unclear, the answer is to fix the system, not to stop enforcing it. And I would encourage this committee to think very carefully about what signal that suspension would send and whether there's a better path forward. And I would also encourage the committee to very critically interrogate about how we got to this point where we have candidates who are filing eminently, and we are all sitting in this room at 4:20 p.m. on Wednesday, April 22nd, debating this form. And then I want to talk a little bit about candidate security. I'm very glad that this is in the bill. The reality of running for office in 2026 is very different than it was 10 years ago, and we should say that plainly. Across the country, we've seen legislators that have been killed. Campaign offices have been vandalized. Candidates have been stalked, doxxed, threatened, and driven out of public service entirely. Party officials, candidates, and elected representatives in the state have received threats that have required law enforcement involvement. And in particular, women candidates have faced targeted harassment campaigns that are designed not to debate their ideas, but to make them afraid. This is not an abstract concern. So far, we've seen Democratic Party offices. Well, I know this is about candidates, but this is a broader conversation where offices have been broken into, vandalized in Texas, Wisconsin, New Mexico in the last few months. The DNC is threatened concerningly often. The New Mexico Democratic Party headquarters was broken into and burglarized. Security footage, because they had cameras, showed an individual breaking through the front door, and they weren't able to rule out political motivation given these times of heightened political rhetoric. In late 2025, 5 Democratic lawmakers received bomb threats after President Trump posted that they had engaged in seditious behavior that he called punishable by death. Senator Alyssa Slotkin's home was threatened. Michigan State Police responded while she was away. Representative Jason Crow's district in Aurora, Colorado was targeted. Representative Chrissy Houlihan's district office in Westchester, Pennsylvania received a bomb threat. Her office noted that it was treating Trump's post as they treat all threats targeting Representative Houlihan. Representative Chris Deluzio had 2 offices targeted in Carnegie and Beaver County, Pennsylvania, and police in Concord, New Hampshire responded to a bomb threat at Representative Maggie Goodlander's office. And Capitol Police recently down in DC told a House subcommittee just in March that threats against members of Congress are growing at an alarming rate, on pace to exceed previous years. Just 1 month before that testimony, Capitol Police arrested an 18-year-old wearing a tactical vest running towards the Capitol building with a shotgun. So all that to say, this is not politics as usual. This is a different environment, and I believe that the law should reflect it. expanding the definition of expenditures to include security costs, so monitoring systems, protective details, cybersecurity, is a recognition of that reality. It says that Vermont takes seriously the safety of the people willing to put their names on a ballot. It says that running for office should not require you to choose between your safety and serving your neighbors. I would only add one practical note that the committee should ensure that guidance is available to candidates about what this provision covers so that people who need it can actually use it. The goal is safety, so let's make sure that the implementation reflects that. My work every day is about organizing. It's about building the grassroots infrastructure that makes democracy function. So knocking on doors, registering voters, running field program, and helping people feel like their voice matters. My job is to help people believe that democracy works for them. This bill matters to every organizer, every canvasser, every volunteer who has ever stood on a doorstep trying to make the case that democracy delivers. This committee has heard that the federal administration responsible for enforcing civil rights law has instead been in court trying to seize Vermont's voter rolls. People want to know that our elections will remain fair, free, accessible, and secure. The question before this committee is not just whether Vermont needs these protections today, but the question is also whether Vermont will have them tomorrow. While Washington is busy making it easier to vote, while Washington is busy making it harder to vote, cutting election security funding, demanding voter data from states, and pushing to end mail-in voting, Vermont is in this room right now standing up for our freedom. So I want to commend all of you for your work. The federal government is not a reliable partner in protecting Vermont voters right now, and Vermont should stop governing like it is. This committee moved the ball forward, and I'm asking you to finish the drive. Does anyone have questions for me?
No, seeing no hands, we are going to move on to our last final witness. Thank you very much for your time. Yes, please join us, Paul.
All right. Thank you. My name is Paul Dame. I'm the chairman of the Vermont Republican Party. So I apologize coming a little bit late to the conversation here. I don't have a campaign speech as good as May's. So I'll just get right into the issue. I think earlier Carol Dawes had mentioned a concern that I had in terms of understanding the application of that phrase language group, because later in that same language, it talks about the political process for becoming candidates. So I didn't know if that is a new burden on anybody who creates training materials like a party, major or minor party, that we need to produce campaign materials in multiple languages. So if there's something else that's not in the bill that's like in the definitions somewhere, I missed that. But I think that's something I was looking at. In terms of the overall concept of that section of the bill, right, we're trying to make sure people aren't discriminated in the way we set up the the electoral process. And I'd be remiss if I didn't mention one of my biggest concerns, and is the way that we draw our state maps and the multi-member districts. Vermont is the last state in the country to have not only multi-member districts, but a mix. I think if we wait until the next map has to get redrawn, you get everybody who's an incumbent, and there's a lot of angling, and that's the worst time to try to come up with fair rules. So I'm hoping that, I know it's too late this session, but I'm sure many of you will be back. And I hope that in the next time we can think about creating a map that either has all single member, all two member, whatever it is, let's come up with an equal number, do it across the board, and do it a couple of years before we have to redraw that map. I had a good conversation with my colleague in New Hampshire. He says one of the ways that we try to eliminate gerrymandering in New Hampshire is we put so many rules into how you have to make the map that it doesn't give whichever political party has power a lot of room to twist the rules. So, when you have broad rules, there's a lot more subjective work there. If you've got narrow rules, it keeps everybody in a box. So the new proposal about sharing, about sharing voter checklists, I hadn't seen that. I don't think there's, if the Secretary of State has a process that's working well, and they want to share it with the town committees, I think that's great. Again, I would be remiss if I didn't identify a problem that I've had with the fact that we have a handful of municipalities now who have a separate voter checklist, those who allow non-citizens to vote in municipal elections. What we've done, unfortunately, is we've created a very simple and easy way to identify non-citizens in municipalities that offer that. Any person who's a voter can go get a voter checklist. And if I can pull the one from the Secretary of State who can vote in a federal election and one who can vote in my town election in Burlington, Montpelier, wherever else gets added, and I compare those lists, you got an Excel spreadsheet, you can compare those lists and find out who's on one and not on the other. So I think that's a concern that never really got addressed by those municipalities who chose to enforce that. And then, the big issue that's been discussed, the financial disclosures. I think it is a burden for regular Vermonters. It's a lot just to figure out, do I want to run? What does that mean? What's that mean for my family, my business? And then it's like, oh yeah, give me a copy of your tax return. One of the most sensitive pieces of information. And I think there were some current concerns in the beginning of last cycle. The auditor put up his IRS form, and because it's a new process that was publicly observable. I think the Secretary of State's office addressed that when it was brought to their attention. But I think that moving that to another organization that hasn't done that before presents some potential privacy concerns. I think that whoever is going to enforce the provisions of the financial disclosure ought to be the one answering the questions. It's not fair to candidates to go to one group or one entity and get guidance and then have somebody else enforce it and say, well, so-and-so told me this was fine. And then the enforcement action comes, that's creates a lot of potential problems that I think could be resolved by putting them in the same place. The ethics committee is kind of new. There's not a lot of continuity there. I've got, if there's anybody who should be concerned about, the partisanship of, the former majority speaker being Secretary of State, it should be the Republican Party chair. But I don't think that we've seen, there's a lot of opportunity to influence that process in an inappropriate way. I think for the most part, a lot of those things are being dealt with by staff. And most of those staff are career people, and I'm suspecting that we're going to have more longevity in a Secretary of State's office than in the ethics committee. But, it's kind of too soon to tell in some of those cases. I think there's a lot of wisdom in having the ethics committee figure out what are the kinds of things that we need to have in the financial disclosure, like coming up with that content idea. I think the Secretary of State's pretty good at administering that stuff. So if they want to say, like, here's what you need to have, any potential partisanship from the Secretary of State gets taken off the table, right? Because you're thinking, what's the worst thing that could happen if you had a terrible Secretary of State in that position? They want to use this financial process to their benefit. They would ask questions that are hard for their opponent to answer that are easy for them. But if you have a neutral process designed by the ethics committee that says, this is what we're asking, and we're not changing it unless you get our permission, I think it really eliminates what I could think of as potential problems with an overtly partisan SOS. And then on one of I'm trying to say, there was one section where there were a couple fines. Let's see, page 316. Oh, yeah, to get context for that again. Related to the civil actions by the Attorney General. There's clearly outlined penalties in section 2 of that. This is again, anybody who's been discriminated against, the voter groups discriminated against. In section 3, it says that the Attorney General can issue an order requiring reimbursement to the state of Vermont for the reasonable value of its services and its expenses in investigating and prosecuting the action. I just want to draw to attention, there's no limit on what that could be, right? The fines in the civil penalty in the category before is limited, 5,000, 25,000 for a second violation. But if you're basically forcing the person who's violated to pay legal fees to the Attorney General, I don't know that there's a cap on that. So I think that's something that you may want to address, or if there's other places in legislation that I just didn't see in the bill, that's something to take a look at. And then the last piece, I noticed that there was language removed where the election officer had a duty to prosecute, or a duty to ensure prosecution to the fullest extent, not to the fullest extent, but a duty to prosecute the ballot revealing portion. And I can see why you can't ask the town clerk to get engaged in prosecutions, but it may make sense that they're the front line. They're the eyes and the ears of any potential problems at a polling place. And maybe what you need to do is have some kind of like mandatory reporting standard. I think if you have election officers who aren't reporting these things to the attorney general, then nobody ever knows that they happen. What the attorney general does with them, that's their scenario. But I think having some kind of accountability for that election official to make sure if there's an issue, it gets passed along, I think is important, even if they aren't involved in full prosecution of it. So those are my thoughts.
Okay. No, appreciate it, Paul.
Any questions?
Anything from the table?
Can I?
Hold on one moment, please. I just want to make sure there's no direct questions here. All right, any questions from the table for Mr. Dame? No. Could you please identify yourself again for the record?
May Hanlon, ED of the Vermont Democratic Party. Something that I've heard that is concerning to me is that because the Secretary of State's office is run well, that they should now do even more work. Whereas because the Ethics Commission is new, they, to me, reading what has already been passed, the Ethics Commission already largely owns the form. So, again, to be frank, because the Secretary of State's office has been on it with distributing resources to candidates to be able to answer questions, to provide a centralized hub for other things, that they should now also be expected to pick up slack in other areas. I don't buy that argument. And I think that we should critically interrogate about the message that would also send. But truly, I don't really care as long as my candidates get this form eventually and someone can tell them what to do with it.
And I'm trying to stay focused on the policy and less the external politics right now, because that's our job right now, is to make sure this function within statute is applied correctly.
You guys are
And
doing a really hard.
cerebral as possible. So, yeah. All right. Rep. Pisno,
So you don't want to talk about the disclosure form, or you do?
but that's like the primary. No, that is the policy.
Okay.
Yes.
So my question is, I don't understand why it can't be really simple. Everybody has a phone system, call the Secretary of State's office, you go to the elections division, they have an answering machine that says, if you want this, push this. Can't you just say, and the ethics department could do the same thing. If you're calling about the disclosure form, you must call the ethics committee at 802 blah, blah, blah. If you call the ethics division and that answering machine can say, if you're calling about election questions, please hang up and dial blah, 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 blah. They don't have to answer the phone because it's not going to go into an internal phone call. It's like, let's keep it simple. They're in charge of the form, let the ethics division get the form right. And this form that we just got is, excuse me, a tear. I mean, there's no boxes, there's nothing. It's just question. There needs to be some graphics done to it so that you can follow it. But then they're in charge of the ethics, or the ethics committee is part of the disclosure that keeps the Secretary of State's office out of it. Secretary of State's office deals with elections questions as they should. I mean, I'm just trying to keep it as simple as possible.
Can I just quickly?
Hold on one second. Yeah. So we're gonna have a ton of time to talk about that tomorrow. Yeah, tons of time. Like we are absolutely, this is just like, it's the cocktail hour right now for this party. And we haven't even gotten to the dinner course. Sorry for my lazy analogy back into my profession. But yes, so there'll be plenty of time to have this conversation to hone it in. But I understand what you're saying. You got to make this as digestible and easy to understand for the candidates, given what exists in statute. That's the ultimate goal, right? All right. Paul, you had a comment?
Yes, you do not have the most recent version of the form. And Lauren, I think you just received an email with the more recent version of the form.
I'm not looking at my emails.
Okay, but it was sent to you a little while ago.
If you could send that to my committee assistant, that would be fabulous.
Yeah.
Yes, that would be a great resource for us.
Lauren has it right now. I just have my little phone.
Okay. Thank you, Madam Deputy. Okay, with that, not to be a broken record, we're gonna do a lot of work on this tomorrow.
We're
So
back at 9:30.
we're back at 9:30 with another. So we have our entire morning dedicated to this conversation.
Oh.
Yep, Redbox says live, Redbox. All right, that was a lot in a short period of time. Good work, folks, and thank you for your patience with that. I know we all had other engagements around the 4:30 hour, so with that,